Mediation. Mediation is a way for two parties to try to resolve their differences in a legal proceeding, whether it be a dissolution of marriage or a parent in action. Mediation means that both parties agree upon a person who is called a mediator, who is frequently an experienced family law lawyer or a retired judicial officer who has experience in family law matters. The most important thing about mediation is that a mediator has no power to make any orders. A mediator is there to attempt to bring an agreement between the two parties by sharing their views of what the law is. Frequently, if you have not been a party to a parentage action or a dissolution proceeding, you probably don't know all of the ins and outs about community property law or support. A mediator can help educate the parties as to what those laws are and what the rules are. Most importantly, people pay mediators. It's not free. However, you're only paying one person instead of paying two lawyers to negotiate a resolution. Mediation is confidential. What do we mean by confidential? That means whatever the parties say in mediation or whatever the mediator says during the mediation sessions cannot be repeated in any subsequent proceeding or in any written communications between the two parties going forward. Mediators will require each party to provide information for the mediator to make decisions. Just as a physician may need tests and x-rays and blood tests, a mediator needs data in order to determine what that person thinks is the likely outcome for your proceeding if you go to court. Mediators will frequently attempt to write up an agreement, but also may frequently require both parties, before they sign the agreement, to seek independent counsel to make sure that they understand the terms of the agreement. After you reach a mediation agreement, you will thereafter have to file a petition for dissolution. Before that mediation agreement can become a judgment and resolve your matters, there has to be a pending action, which is called a petition for dissolution, and a response filed by the other side, or an agreement that the matter can go by what we call default, because we have a written agreement that resolves the issues between the parties. Mediation is usually a cost-efficient way to resolve a dispute, and it requires both parties to provide full information for the mediator in order the mediator to give a recommendation. Mediation can occur before or after a petition for dissolution and a response is filed, and is frequently a very cost-effective and less stressful way to resolve disputes. Mediators are trained in dispute resolution, and GRIFFIN Donnell has qualified mediators to help you resolve your matter.